Hello and welcome to the Minimum Competence episode for Monday, April 20th, 2026. I'm your host for today, Andrew Leahy, assistant teaching professor of law at Drexel Klein School of Law. On today's episode, the Supreme Court is weighing SEC disgorgement limits, airline merger tensions, and Trump's $10 billion IRS lawsuit settlement talks. Let's remember, some people feel the rain, others just get wet. And read today's legal news. On this day in legal history, we have a dark day in American history. On April 20th, 1999, a mass shooting at Columbine High School became one of the most consequential events in modern American legal history. Two students carried out a planned attack that resulted in the deaths of 13 people and injured many others, shocking the nation and prompting immediate legal scrutiny. In the aftermath, victims' families filed multiple lawsuits against the Jefferson County School District, arguing that officials failed to act on warning signs and threats. These claims raised difficult questions about foreseeability and the extent of a school's duty to protect students from third-party violence. Courts examining these cases often had to balance negligence standards against doctrines like governmental immunity, which can shield public entities from liability. The tragedy also intensified national debate over gun control laws, particularly regarding background checks and access to firearms by minors. Legal discussions extended to the role of parents, as some lawsuits attempted to hold the shooters' families accountable for failing to secure weapons. Additionally, Columbine influenced how courts and policymakers viewed threats made by students, contributing to stricter enforcement and zero-tolerance policies in schools. The event led to expanded use of security measures such as surveillance, school resource officers, and emergency preparedness protocols. Columbine's legal legacy can be seen in later case law addressing school liability and student safety, where courts often referenced the limits of institutional responsibility. It also shaped legislative efforts at both the state and federal levels aimed at preventing school violence. The case highlighted the challenges of proving causation in negligence claims involving unpredictable criminal acts. Over time, it became a foundational example in discussions of tort law, particularly in cases involving public institutions and risk prevention. The U.S. Supreme Court is set to consider the scope of the Securities and Exchange Commission's authority to seek disgorgement, a remedy that forces wrongdoers to give up profits obtained through illegal conduct. The case arises from a challenge by Ankarac Sriptek, who was ordered to repay more than $3 million tied to a fraudulent stock scheme. Although the SEC's general ability to pursue disgorgement is well established and supported by Congress, the dispute focuses on whether the agency must prove that investors suffered actual financial harm before recovering those profits. Sriptek argues that the SEC failed to show his actions caused investors measurable losses and therefore should not be entitled to the repayment order. The federal government, defending the SEC, maintains that disgorgement is meant to strip unlawful gains from violators rather than compensate victims, making proof of financial harm unnecessary. Lower courts, including the U.S. Court of Appeals for the Ninth Circuit, sided with the SEC's broader interpretation of its authority. However, other appellate courts have disagreed, creating a legal split that prompted the Supreme Court to review. The case highlights the significance of disgorgement as one of the SEC's primary enforcement tools, with billions of dollars recovered in recent years under different administrations. The outcome could clarify the limits of the agency's power to reshape how securities fraud penalties are pursued, particularly in cases where direct financial harm to victims is difficult to quantify. American Airlines publicly denied reports that it is considering a merger with United Airlines, stating that no discussions are taking place and that it has no interest in pursuing such a deal. The denial followed speculation that United's CEO had raised the idea during a recent meeting with federal officials. American emphasized that a merger between the two major carriers would likely harm competition and consumers, signaling concerns about antitrust implications in an already concentrated airline market. The company also suggested that such a combination would conflict with broader regulatory principles aimed at preserving competition. Instead of pursuing a merger, American stated it will remain focused on its own long-term strategy and operations. United did not comment on the reports at all. While a deal between the two largest airlines appears off the table, smaller industry transactions are still moving forward. Allegiant Travel Company is proceeding with its acquisition of Sun Country Airlines after receiving regulatory approval to operate both carriers separately under shared ownership. Similarly, Alaska Airlines previously completed its purchase of Hawaiian Airlines in 2024 with government approval. These developments highlight that, despite scrutiny of large mergers, regulators are still permitting consolidation among smaller airlines under certain conditions. Lawyers for Donald Trump and the Internal Revenue Service are negotiating a potential settlement in Trump's $10 billion lawsuit over the leak of his tax returns. The parties have asked a federal court to pause the case for 90 days to allow negotiations, suggesting a resolution could avoid extended litigation. The lawsuit stems from disclosures made by former IRS contractor Charles Littlejohn, who leaked Trump's tax information and data on other wealthy individuals to media outlets. Trump and co-plaintiffs, including his business entities and family members, claimed the leak caused financial damage and reputational harm. Littlejohn pleaded guilty to unlawful disclosure and was sentenced to prison, establishing the underlying misconduct. A settlement could raise complex issues because Trump, as president, is effectively suing a federal agency within the executive branch, creating conflicts for government lawyers representing the IRS. The case also carries financial implications, as any settlement payout would likely come from public funds, obviously. Beyond this dispute, Trump has pursued several other high-value lawsuits against media organizations, reflecting a broader legal strategy tied to alleged reputational and political harm. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, gray skies can carry their own kind of beauty.